Good morning. Welcome to our second day of our January oral arguments. The first case this morning is People versus Ghunaim. And this is a 15-minute mini oral argument on the application. You both have 2 minutes of a free fire zone, and you may reserve time for rebuttal, but we ask that you keep track of that time on your own.
I would like to reserve some time for rebuttal. My name is John Ulacki. I represent the defendant appellant Maher Ghunaim. This case boils down to whether or not Miranda is still effective and meaningful, or is it meaningless today? I'm sure you've watched the video of the interrogation, and what is striking is when Detective Stephan says, "Police officer, I'm here to help you." In effect, what happened in this case was, in our opinion, an ambush. Detective Stephan believed Mr. Ghunaim was guilty and wanted to confirm it with his own words. There were promises made of, "I'm here to help you. If you want to see your daughter again, you'll tell me what happened. You'll feel so much better if you do." He was never given any Miranda warnings. And it's also our belief that as far as the custodial environment, Detective Stephan used the hospital as a surrogate for a police station. Well, the interrogation lasted about an hour. To say that it was an interview that was calm, cordial conversations is totally wrong. Mr. Ghunaim several times asked the detective to shoot him, to put him out of his misery. She had every reason to believe he was in a fragile state of mind. We have a man.
I did watch the video, as you said. I'm sure we all did, and I'm frankly, I don't know that it helps you all that much. There has to be some coercive activity. Was it, "I'm here to help you"? Is that coercive?
It's what, Your Honor? I'm sorry.
Well, when you said the statement, "I'm here to help you," was that coercive? Help me understand from your understanding of the video, where is the coercive activity?
It went on and on and on.
Well, give me specifics. Help me understand.
You have a gentleman who was there on a suicide watch in a very fragile condition. He was vulnerable. He lacked familiarity with our laws. There's no indication that he was familiar with what rights he had at the time.
But does that amount to coerciveness?
We believe it does.
Why? What in the case law tells us that? That someone's unfamiliar with the law, does that make it coercive to go in there and after giving Miranda warnings and asking questions? Or, in my view, acting compassionate? She seemed to be genuinely caring about his well-being. Now, even if it's an act, does that make it coercive?
To be candid, we're in a whole new area of the law. I've looked at the cases, and there are two that are somewhat similar, but not exactly the same. It's going to be up to this court to decide if Miranda is still applicable.
Okay.
So let's assume I agree with you that there was some sort of a custodial environment and that Miranda applies. When should the Miranda rights have been given?
It should have been given immediately when Detective Stephan announced her presence with a CPS worker.
Because usually that's in an environment where police show up to question someone at their home, or it's not always right at the start. There's often a point that it switches to become a custodial environment where someone basically doesn't feel free to leave or, in this case, terminate the interview. So is it your position it's from the minute the detective arrived?
That would be our position, yes.
And is that a bright line rule that you're asking us to adopt, that when someone is in a similar situation to your client, where they're in a hospital bed with these facts, that's when the custodial environment begins?
Well, yes, he was hooked up to some machines. He was given some sort of medication. He had a suicide watcher who was told to leave the room. And it's our belief that there's no doubt about it, that the hospital was used as a police station.
So I hear what you're saying, but we need like specific tangible things that add up to a custodial environment. So having viewed the video, I noticed, the detective arrived. She did ask the suicide watcher to leave, which she, of course, alleges is partly to give privacy for interview purposes, recognizing there could be multiple reasons. She turned on the lights, she set up a camera, and then you have a defendant obviously hooked up to the IVs. So your contention is those things all together would add up to a custodial environment?
Yes, that's
Does
correct.
the camera matter?
Pardon?
Nobody really talked about the camera. Does the camera matter?
The only thing that matters is that it does confirm what our belief is. And therefore, yes, the camera mattered because it showed the totality of circumstances and would indicate why there was a need for Miranda warnings.
Thank you.
Does the court have any other questions?
Do you think all questioning in a hospital room is custodial?
No.
So what has to happen for it to not be custodial?
Well, you've got an active treatment going on.
Well, wouldn't that be the case every time somebody's in the hospital?
Not necessarily, because somebody can be in the hospital without being hooked up to monitoring devices and some form of prescriptive medicine. Those are distinguishing factors, I believe.
Is there any evidence in the record that the medication that was being administered could affect defendant?
There's no indication in the record.
Okay, thank you.
But we can assume, I believe, from what we know, that this started out with a suicide attempt, a potential heart attack, and a transfer of hospitals, and Detective Stephan shows up the day after he's transferred to another hospital in the Detroit area. I thank the court very much.
Good morning, and may it please the court. My name is Christopher Candela, appearing on behalf of the Eaton County Prosecutor's Office. In this case, the defendant was asked and agreed to talk to the detective. Detective Stephan closed the hospital room door, and she tells the defendant that she's doing this for his privacy due to the sensitive nature of the discussion, and the defendant thanks her for doing that. When Detective Stephan turns the lights on in the room, she doesn't just turn them on. She asks him, she tells him, I'm going to turn the lights on. Is that okay? Is that all right? And he agrees to that. He says that's all right. She sat away from the door, on the opposite side of the room from the door, leaving the pathway between the defendant and the door completely unobstructed. The door remained unlocked, and the defendant was aware of that because people entered and exited the room, hospital staff, during the course of the interview. This really wasn't a hostile, it was not a hostile interview. There's no formal restraints by law enforcement. There's no show of force. There's no threatening language or actions by the detective. Defendant's emotional state that we see in the video, because I know the court has reviewed the video, really appears to be him processing and discussing processing through what he perceives to be the failures of his life. The things that have gone wrong in his life. And so it's a force not driven by police, but driven by him and his own moral compass and internal to him. So even at the start of the interview, going to the statements about The detective said she was there to help. Well, the defendant asked her for help. And it's known that he has a drug and alcohol problem. And she agrees, she says, I will help you, I'm willing to do that. And she's done that in the past when he was in another state and she had contact with him and he needed emergency assistance. She called local law enforcement in that state and sent them to his location to perform a welfare check on him. And he ultimately ended up receiving medical assistance for that.
Counsel, good morning and
Good morning.
welcome. And does it matter that he was hooked up to an IV and wasn't really mobile?
I think that's one of the factors that the court should consider. I think the court should also consider the fact that there's nothing in the record to say whether or not he could get up and walk, whether or not he was able to move from that hospital room bed. And we know that the IV line was on wheels, and we know it wasn't plugged into the wall, so it could move with him. So I think it's a factor that the court should consider. I don't believe it's a determinative factor.
Is it reasonable
What's
that he
that?
could leave?
I think he's in a hospital room bed. I'm not going to say that I would expect him to get up and walk out of the room if he wanted to terminate contact with the police. But I think under the totality of the circumstances here, the conversation that's happening between the detective and defendant, a reasonable person would have felt free to tell the detective, I want to talk to you. And that's indicated by the fact that she asks him, are you willing to talk to you? I want to talk to you. Is that okay? And he says, yeah, I'll talk to you.
What I'm struggling with, she asked him if you want, are you willing to talk to me? Without without saying, you don't have to, right? I mean, and that is a relevance to the voluntariness of whether or not he was advised of that. Maybe not full-fledged Miranda rights, but he wasn't told, you don't have to talk to me.
That's correct. He wasn't told that. Miranda rights, whether he's read his rights, is one of the Cipriano factors. No single factor is determinative. But I think the fact that an individual may be inclined to talk to the police, that's an internal factor for them. That's not a coercive aspect by the police. The fact that somebody is a police pleaser or inclined to talk to the police is not a factor that's being exerted by the police onto him.
Can you help me also? What I'm struggling with, or what seems problematic to me, is that the reason why she was there in the room, right, why she came to the hospital, I think it's clear, at least from the end of the video, that she knew where he would be staying. She had some access to his brother, I think. But at the end, she says, she releases him, there's no question, but says, I know, you're staying wherever this is, you got a phone, you got my number. She shows up there, so that questions to me the necessity to do it in the hospital room. She shows up after having participated in the complainant's interview, right? So knowing that he's already been accused, at least by the complainant, and is there, I think she states pretty clearly, politely, I will give you, but pretty clearly that she needs him to admit it. She needs him to say it in his own words. But because she's police, a couple things. The dismissal of the suicide watcher, in setting up the video, and then at one point somebody comes in from the hospital and she, again, politely asks them, hey, can you come back? Would you mind coming back later? And that person says yes, but then sort of comes back in and says, what outfit are you with? And she reiterates that she's with the sheriff's department, suggesting that the reason why she's able to stay there without the suicide watcher, to be able to videotape the interrogation, and to do so without the presence of other people, is because, in fact, she is the police. She's exercising control over that hospital room. Why is that not a problem, or at least highly relevant to whether or not she had established a custodial environment?
Sure. So the presence of the suicide watcher, the dismissal of the suicide watcher, is not determinative in this case because, one, we don't know if that's a volunteer or not. I would assume it probably is. But my understanding is that there just needs to be somebody present in the room to ensure that he doesn't attempt to commit suicide. The detective being there, a CPS worker being there, would be sufficient for those purposes. Asking if she can leave, the hospital staff says yes, she can. We don't know if they would have that same response for a family member or not. Presumably, if family was present in the room, they could do the same purpose as a suicide watcher, be there to ensure that the defendant isn't going to attempt to harm himself in some way, or to report to somebody or bring attention to somebody if something was to occur. So I think the fact that the suicide watcher is not in the room, it makes no difference because we do have other people in the room that can serve the same purpose. Setting up the body cam, I think is just good detective work, good police work. And the reality is that there's oftentimes, there's case law that says that a police interview room in and of itself is not necessarily a coercive environment. And most police interview rooms have video cameras rolling in them. So I don't think the camera footage, her setting up a body cam is determinative of custody. And that's not.
Can we turn back to the line of questioning that Justice Zara had for Brother Counsel about what was coercive here? And Brother Counsel seemed to indicate that it was the position that his client was in, and didn't give us examples of what law enforcement did that was coercive. Does that track with how you see cases that we've had on coercive police tactics?
The cases that I've seen come out of this court where you found there to be coercive police tactics have much higher level of coercive force by the police. And an example of that is People versus Stewart, a case very recently decided by this court. I'm sure the court's familiar with the facts, but that's an example of a case where the interview occurred with an 18-year-old over the course of 3 hours. It happened in the very early hours of the morning, I think 3:30 a.m. It was in the parking lot of a hospital. And the accusatory nature of that investigation or that interview was substantially more than what we have here.
And was that because of the actions of law enforcement, or because of, again, the situation, that defendant was in at the time? I'm trying to understand what the argument being put forward that a coercive environment, or a coerciveness can happen in an environment just based on the pure circumstance of where the defendant is.
And I think that is an argument that I'm trying to understand too. I don't believe that the environment itself, and I think this court has said so in previous case law, the environment itself does not make a coercive environment.
What about those factors that I just talked about, the facts of this case of maybe you would disagree that they aren't sufficient to establish a custodial environment, but that is conduct of the officer, not just where it happens to be. So the filming, dismissing the suicide watcher, closing the door, telling somebody to come back later, and representing that they're the police, are those relevant to determining whether or not there was coercive behavior sufficient to say that it wasn't voluntary?
I think we have to draw a distinction between police conduct and coercive police conduct. Everything that you've just mentioned, as I view it, is just normal police conduct, including representing that you're from the sheriff's department. If she had gone in there and interviewed him and not told him that she was from the police department, that would be a whole nother issue. So the fact that she's informing him of that goes to the knowing and informed and voluntary nature. He knows he's talking to the police. The fact that somebody comes in and she says, could you maybe come back later? It's for the cohesiveness of the interview. If he had said, well, I need to do X, Y, and Z for the defendant as part of his medical treatment, I have no doubt that the detective would have allowed him to come in and perform those treatments. And if the defendant had said, no, I want to talk to this individual, that's my doctor, I have questions for him, again, I have no doubt that she wouldn't have raised an objection to that. I mean, those aren't facts in the record, but those are things that I can reasonably presume. So it's police conduct, but it's not coercive police conduct. And I think that's where we have to draw that distinction of not everything that an officer does in an interview or in an investigation is going to be coercive and go towards.
So do you think for evaluating whether or not a statement was voluntary and looking at the requirement that it be the product of coercive conduct on the part of the officer, that inquiry only pertains to how they can, like, how they're questioning, the things they say, you know, whether they're polite or antagonistic or that sort of thing, or can it be the environment in which they set up in order to have perhaps a very calm conversation or calm interrogation? Because there's no doubt it was an interrogation here.
Absolutely.
Right? Nobody disputes that.
Nobody disputes that. This was an interrogation. The people's position is just that it was not custodial, requiring Miranda rights.
And that it was voluntary.
And that it was voluntary, absolutely. And certainly.
Is it voluntary? I mean, it didn't appear that the defendant, based on his comments, the way he spoke, I mean, do you really feel his state of mind allowed for it to be voluntary?
I do.
He's on suicide watch. He was slurring his words. I don't think it's normal for someone to say, please just, I mean, genuinely mean it, to say to someone, just please shoot me. I mean, do you think that his state of mind put him in a place where he was voluntary? Where basically his mind allowed him to perform in a voluntary manner?
I do, and the reason for that in this case is because the defendant has these moments where he's worked up and he's saying things like, please shoot me, and he's crying. And then he has these moments where he calms down and he has clarity and he's speaking coherently, he's answering the questions coherently. I didn't quite notice the slurring in the speech, or the little bit that I did notice, I guess I attributed that to kind of the accent that's going on in the conversation. But when I look at the interview, what I see is somebody who's dealing with internal factors. He's dealing with, like I said before, what he perceives to be the failures of his life. He's talking about something he doesn't necessarily want to relive, the fact that he sexually assaulted his stepdaughter. Those are things that are likely to bring out strong emotional responses from people. But that alone does not make somebody incapable of giving a voluntary statement. The fact that he's processing through those things. I think that's just part of the process.
When I watched the video, I concluded Detective Stephan was acting with compassion and concern toward the defendant. Let us assume that that was not genuine and that it was faked for purposes of pursuing a discussion. Is there any case law out there that would say that type of conduct constitutes coercive conduct or inappropriate conduct?
Not that I'm aware of. I know there is some case law out there that says that police can lie to a defendant. I believe that is noted in the Stewart case as well. And the lying can be a consideration in the factors, the Cipriano factors. But the fact that I'm not aware of any case law that says that, saying, you know, I'm here, I'm willing to help you, is going to render it an involuntary statement.
Counsel, I also would love to know, what are your thoughts on, I realize you state it's not custodial. We've already covered some of the preliminary factors that could be examined, the setting up of the camera, the lights turned on, the asking to clear the room. Defendant obviously attached to an IV pole. I tend to think that the relevant inquiry isn't, could he get up and step away and walk out? He probably wasn't able to do that, but could he terminate the interview? Probably that strand of cases makes sense to examine. What in your mind, what would have turned this custodial? What would need to happen for it to become custodial?
Well, I think there's a lot of factors that could have happened had she handcuffed him to the hospital bed, right? That may have, that would be, again, another factor that would go towards a custodial environment.
Sure, but police, I mean, we found, there's plenty of cases where we find custodial environment and they're not handcuffed.
Sure. I think if we look at that Stewart case, and that, I think that's really where we can draw a distinction between the coercive conduct in that case and the conduct in this case that wasn't coercive. The accusatory nature, the brother counsel notes that Detective Stephan arrived at the hospital room already convinced that the defendant was a suspect in this case. That's typically the case in every interview. Detectives don't just go around interviewing random people across the state to try and find suspects. But in Stewart, the detective almost immediately starts accusing the defendant of, being involved in robberies and, having conflicting stories. That's not something we see here. She's not accusing him of anything. She's asking him what happened, and he says happened like she said. You're here to
Right,
talk
and I
to me.
could say a lot of that goes to whether it's voluntary or not, but I'm wondering sort of what, it seems to me like the factors for determining a custodial environment are pretty objective, like, adding up what happened when she entered the hospital room.
I would agree with that. I think the factors are objective, and I think this court has delineated longstanding case law and rules on this specific thing, and has had case law on hospital interviews that answers this exact question. And given the facts in this case, and under those factors, the Barrett factors, this just is not a custodial environment.
Thank you. Your time is up.
Oh, thank you.
I don't believe any rebuttal is required at this time. Does the court have any other questions for me?
Can you help me, I think, watching the video, what's your response to the argument that while he was incredibly upset and distressed and said things like, was crying and asked the officer to shoot him and that, how do you draw the distinction that that was because he was unable to sort of knowingly and freely give a statement as opposed to being horribly upset and despondent over the conduct or the incident and the issue that's going on? Because he can be very upset, right? He can be crying, he can do all that. That doesn't necessarily make it involuntary unless it's something, that's taking it, how are we supposed to say, because it's the environment or because of the conduct of the officer that is causing him to be so upset and therefore involuntarily saying things? Maybe we can't know that.
It's hard to say. I really can't answer that question because we can't get into his mind. All we have is the video record of what actually transpired.
Okay.
I thank the court.
Well, before you say that, I just want to get clarification on just one thing, if I could. At what point do you feel, or does your client feel, this was custodial and that Miranda should have been given? I know we've been talking about this a lot. I just wanted to get clarification. Like, when should Miranda have been given? Specifically.
I think at the beginning of the interview.
But that means when she comes into the hospital room, she should have Mirandized him right at that moment?
Well, I think once she took control of the hospital room, that's when Miranda should have been given.
Took control by asking the watcher to leave? I just want to get a really specific thing as to when this starts. When she came in and asked the suicide watcher to leave, like, what was the specific time that this was custodial, and what was the specific time that Miranda should have been issued?
When she had the suicide watcher leave, turn on the lights, and explain to Mr. Ghunaim why she was there, at that point, she should have advised him of his Miranda rights.
Thank you, counsel.
And then can you go back and give us even just a few examples of law enforcement's actions that were coercive? Law enforcement's actions.
It's our belief that you have someone who is not familiar with our laws, who is in, and
I think you're going down the line that you did before, which I understand the situation that you believe your client was in that created a coercive environment. But what we look at is action by law enforcement that was coercive. So I'm asking if you could point to anything during the interview that you believe was coercive on behalf of law enforcement.
there's nothing I can put my finger on. It's just a total set of circumstances that we're dealing with in this case and the conduct of Detective Steffen.
Thank you very much. Thank you both. The case will be submitted.
Thank you.